Welcome to Human Rights Asia Weekly Roundup. I am Ansar Stianes. The second meeting of the Asian Alliance Against Torture and Ill Treatment concluded on November 13 in Hong Kong, after 3 days of presentations and discussions with Asian parliamentarians as well as human rights defenders and other experts in the field. The meeting was co-organized by the AHRC and Danish organization Dignity, which works on torture issues worldwide. Today's special news roundup will provide you with some extracts from the meeting. We start with a few snippets from the opening statements to get a sense of the agenda of the meeting. Here is John Clancy, Basil Fernando, and BJ Francis, all from the HRC, as well as Eric Wen from Dignity.
As we begin this second meeting, let us start with a short reflection on the overall aims of the project to promote the Convention Against Torture, CAT, and our progress in working to prevent torture in Asia. Whenever we hear of attempts of any kind by any person to defend the use of torture, we need to remember the clear message of the Convention Against Torture. Torture is never permissible for any reason.
Why are we afraid of having better policing? See, the idea of this meeting in particular is that to go beyond the pious expressions of support for CAT, for the Convention Against Torture. Go really into trying to understand why is it that still there is support for the kind of system that exists in these countries. Then we will find not having a better policing system is a political problem.
Often when we speak of a convention or a global norm-setting document, we often tend to speak of the convention purely from the basis of the articles that we read in the conventions and try to apply it in the domestic law. We critique the domestic law, how far it has not been complied with. I propose that it is much more an interesting journey if we try to understand it from a very historical perspective of what torture is, why is it considered today as a heinous crime or one of the most heinous crimes, why internationally it is seen or is looked at or looked down as an offense that calls for the highest forms of punishment, why regimes are condemned for engaging in torture. And that is an interesting journey, or that journey would be interesting if we understand how torture was seen, used, how it was condemned from time immemorial.
Now, back in our meeting in 2012, it became a historical turning point. It was the first time I had the opportunity to sit with parliamentarians, human rights defenders in a safe place here in Hong Kong, and we discussed the political will to stop torture in Asia. I think it was actually maybe the first meeting we had here in Asia of its kind. We discussed political tactics, we voiced our concerns, and we agreed to a vision of a world without torture.
Each of the Asian parliamentarians had the chance to deliver a presentation as they saw fit about the pressing issues of torture and ill treatment in their respective countries. We start with a short clip from the presentation by India's Mon Kikon, a legislator from the state of Nagaland in India. Also on the first day of the meeting, representatives of Indonesia and the Philippines presented their views. Indonesia was represented by Taslim Chaniago, a member of the Indonesian House of Representatives, and Vina Octavia, who is the director of Padang Legal Aid Institute in West Sumatra. Representing the Philippines were Guillermo Romarate, a senator from the Philippines, and Ernesto Anasarias, the executive director of Balai Rehabilitation Center. Over to them.
You would find that northeastern region is an area where Armed Forces Special Powers Act is applicable. In the region where AFSPA is applicable, the area is heavily militarized. And when you have immunity, impunity is on the rise when you have immunity given to you by AFSPA. And so when you have such powers, torture and custodial deaths are a natural or are something which occurs on a daily basis or which people are immune or people are used to it now.
Walaupun saat itu Polisi Republik Indonesia tidak lagi berada di bawah Angkatan Bersenjata Republik Indonesia, tapi tindakan kekerasan masih tetap juga berjalan di Kepolisian Republik Indonesia pada saat ini.
Praktek penyiksaan di Indonesia itu sudah melanggar konstitusi dan perjanjian internasional yang telah diratifikasi oleh Indonesia. Kemudian hampir terjadi dalam seluruh sistem peradilan di Indonesia, baik waktu penangkapan, penahanan, pemeriksaan maupun dalam menjalankan penghukuman, serta dilakukan oleh pihak kepolisian secara fisik, psikis, seksual. Yang ini bukan lagi persoalan oknum kepolisian, tetapi sudah terjadi kelembagaan secara struktural.
I share fully well the premise that put forward by the Asian Alliance Against Torture and Ill Treatment, that widespread practice of torture is incompatible with equality and freedom and negates the fundamental premises of democracy.
As we all know, torture will not simply go away just because the law says so. Neither are public statements made by authorities and human rights training enough to bring justice to those who suffered from cruelty and ill treatment from state agents who are supposed to protect their rights.
Bangladesh followed in the second day of the meeting with Muhammad Fazlul Azim MP talking about the newly enacted anti-torture law, as well as Burma's Member of Parliament, Jae Yawu, describing the issue of torture and ongoing conflict in the state of Kachin.
I am very pleased to report to this August conference that Bangladesh has enacted the long-cherished law criminalizing torture on October 24, 2013, titled Torture and Custodian Death Prevention Act 2013.
And there are very, very few who brought up these torture cases in the parliament. There are cases that you are going to talk about, sensitive cases like torture, and some cases that will be against the military. We are stopped. We are given warning. Don't talk about this because it is like confidential.
Pakistan and Sri Lanka presented on the last day, with Farooq Naik expressing optimism with where his country is heading, while Sri Lanka's Iran Wickremaratne was more concerned about recent developments. Here are some extracts from their presentations.
The policing system, which needs critical reforms to end these inhuman practices, is often prone to political interference and influence by powerful vested groups and the politicians. Unfortunately, there is tendency among the politicians and the people at the helm of the affairs and the powerful groups to use it for their own interest and nefarious design, the police. It is a system that encourages the use of torture and extrajudicial police accesses as a tool to keep the common people and the political opponents under subjugation, suppression, and intimidation.
You see, if laws can solve a country's problems, then generally our set of laws are fairly decent. If institutions can solve or create democracy, then we also have institutions. So I think the real issue that we face is beyond laws and even beyond institutions, because either there's impunity and the laws are not being implemented, or there are institutions and the institutions are ineffective and they are politicized. So we have to actually dig much deeper in actually trying to see how we can actually make our society function in a more humane manner.
That was Pakistani and Sri Lankan parliamentarians presenting their views on torture issues in their countries. The participants were also fortunate to have experts from Hong Kong and Denmark contributing to the discussions. Veteran Hong Kong barrister Y.L. Cheong spoke about the steps taken to turn Hong Kong into a torture-free society, and human rights lawyer Mark Daly presented around issues of torture refugees claimants' battle with Hong Kong authorities. From Denmark, Dignity's expert on police and military reform, Dr. Klaus Kolt, presented his academic research findings on the necessary institutional precondition for an effective reform of security forces. Over to those presentations.
I'm not saying that the police in Hong Kong are particularly civilized. I think all police around the world belong to the same species. And it's just that I think looking at the essence of our system here is that if they're involved in irregular practice, or put it this way, if they are involved in brutality, if found out, they will have a price to pay, and often it could be a huge one. So I think this is why torture, under the system, is a rare or even non-existent issue.
You're in the process of discussing torture in your various countries. My perspective is that I see those fleeing torture and persecution from those various countries, and they arrive at Hong Kong.
In many countries is that the military and the police are more or less turned into one institution. And then you can see we take the interrogation part of the police and the violent part of the military, and then we say interrogation plus violence, and then you have torture. So in a way, I'm saying you need to separate police and military. It's extremely important.
After the conclusion of the meeting, we sat down with one of the participating parliamentarians, Ashok Agarwal, a senior lawyer practicing at the Supreme Court of India.
See, most of the torture, to my understanding, that occurs in India is connected with crime. Suspects or so-called suspects are taken into custody and they are tortured. The police is the instrument, is the primary instrument of the state's violence. So private parties who have the capacity to either purchase or to manipulate this instrument, they use it. And police are frequently hired in courts, I use the word, to perform this task. Everywhere it happens, in every part of the country, in virtually, I would say, every police station in the country.
With us in the studio now is Pijo Francis, the Executive Director of AHRC, who will give us a rundown on what the meeting achieved in his view. Mr. Francis, welcome to the studio. What is the objective of this meeting?
The main objective of the meeting was obviously to discuss about the practice of torture in Asia and also learn from the parliamentarians and the human rights defenders two separate aspects of why torture is endemic in Asian states. From the perspective of the parliamentarians, to understand why torture is difficult to be contained institutionally. What are the impediments which prevent or prohibit or poses challenges to states in formulating policies, in implementing policies, and also in addressing the question of torture, also from the victim's perspective. From the human rights defenders, we wanted to know how and what are the patterns in which torture happens in Asia, and what is their opinion about when it comes to police reforms, where the reform initiative should begin, and also to discuss further how both the human rights defenders and the parliamentarians, representing thousands of people from their constituencies, how both these separate but unique entities could collaborate in the fight against torture.
In your opinion, did this year's meeting achieve the goal that you mentioned?
To see whether the actual purpose of the meeting, actual goal of the meeting has been met, we will have to wait and to see how much of the agreements that we have arrived at in this meeting is actually practiced in the months and years to come. And when we see the results of that practice, then we can affirmatively say that the goal has been achieved.
Thank you, Pijo Francis. That is all for this week's Human Rights Asia Weekly Roundup. Thank you for joining us and hope to see you again next week.